Can see my screen, isn't it? It's at the word now.
Can.
Can okay, very well. We are going to start with the discussion of criminal procedural code. So I have done 4 questions actually, and I plan to discuss 4 questions with you today. Okay, so the first question concern about what? Concern about wait, let me just adjust my pen a bit. Mainly concern about search and seizure. Okay, that means to say here on the facts itself, one police group they had actually raided a place. They raided a place because they received information about a stolen property, isn't it? Okay. And then at the same times, when they reach the house, they do not break in. And this is a search without warrant. You must know your search. There are 2 types of search. One is search with warrant. One is search without warrant. Warrant, where you get it? You get it from magistrate court. But this is not the case here because the facts is silent on the part of warrant. So this is presumably a search without warrant. Okay. And then subsequently, there was one potential OYDS lah, orang yang disyaki. OYDS, the suspect is called Chan. And then there's also involved whether Chan was arrested in the question or not. Okay, as simple as that. Okay, so first, they check whether you understand what amount to an arrest. Okay, an arrest, if you look at CPC, the only statutory provision for arrest by police, we have private arrest and also the arrest by the authorities. Okay, if there is authorities, automatically your reference should refer to section 15, sub rule 1. How does one arrest can occur? Okay, and there are actually 2 types of arrest. One is actual arrest, and second thing is constructive arrest. Okay, why is this very important here? Actual arrest is quite simple, meaning to say the police have used physical force, touch or confine the body of the person so the person cannot go anywhere. So this is by physical mean or by words. But words or conduct also can. So long the person said that, okay, you are under arrest, you sudah kena tangkap, or you are being surrounded or circled by a group of police officer, then you can't run away. The key word here is you lose the liberty to go anywhere because of this the conduct of the police, then there is an actual arrest. Okay, so constructive arrest, even though there's no formal word, but eventually a reasonable suspect would think that he's no longer free to go. Like the one that I have projected to you. One group of police actually surrounded the accused. The accused is at the middle of the circle. He can't expect to run away, isn't it? That's why there is a constructive arrest. Okay. So applying the facts here, you see, from the facts itself, first you have to identify whether there is a touching or not. There is no touching here, isn't it? The body was also not being confined by any of the police force, isn't it, in this question? So section 51, sub rule 1, the limb 1 is totally out. And you can see the SP Jacob did say something to Chan. But what he said is actually ikut saya di mana bilik awak. And then subsequently, it's just the exchange of words, whether which one is your room, my room is there. This is just merely showing the direction, isn't it? So this is not yet arrest. Okay. And subsequently, because you have to evaluate the factual circumstance of the case, okay, since there is no express communication of arrest, and I will submit so lah. Okay, why I need to submit so is that because the house itself is a quite big one, isn't it? And Chan will still remain in his own house. He can still walk from one room to another, probably, because the direction conversation itself doesn't cause any restraint. It doesn't cause the liberty or the freedom to go elsewhere to be stopped by the police. Okay, so this is not yet arrest. Okay, but I would say that probably when the police found the credit card as well as the machines that involved in the forgery of this credit card, then the arrest would have occurred. But this is already out of the facts given. So I will submit as my final answer because there is no physical arrest and there is no constructive loss of the liberty. The arrest has not happened. Okay, has not happened. So please put down section 15 and also classic case of Shaban in this question. Very important. So arrest is very simple. And subsequently, question B, they try to project to you that if there is an arrest, whether the actual time of arrest is utmost importance. Okay, arrest is very important in criminal case um, because of what? Okay, without arrest, like I said to you, orang yang disyaki, the OYDS, the suspect, will still enjoy the freedom to his life, correct? So this is very important. Our article, this federal constitution provide freedom to life. That means to say you are allowed to go anywhere. But once the arrest has been effected, a person lose the liberty to go anywhere. So arrest itself will give rise to rights, or in a very basic term, human rights lah. Hak asasi kemanusiaan. If there is no arrest, that right cannot occur because you are free to go. The police need not take care of you. So what are the rights that is available to those being arrested? Okay, first, under Article 5, Subrule 4, and also Section 28 of CPC, the maximum time allowed for the enforcer, particularly the police, to lock up a person is up to 24 hours. Very important, 24 hours. If let's say a police arrest a person, a suspect for more than 24 hours, his arrest is unlawful. Very, very important. If the arrest is unlawful, it will give rise to civil liability. It will give rise to civil action. For example, forced imprisonment. And you can sue the government of Malaysia and get a good sum of money. Okay, very important, And when you get arrested, automatically, automatically, by virtue of Section 28A CPC, you can inform your friend, your relative, your spouse, or your next of kin to inform them your whereabouts. Where are you? Okay, you can call your husband, for example, to inform him that I was arrested by the police, which balai, so that people can locate you. This one also very important, and you can also contact uh, a lawyer to check with him what are the legal advice available to you. Okay, the only case is that you referred in the subsection of section 28A CPC, only a DSP. Okay, this one is just for your knowledge. DSP, Deputy Superintendent and above, has the right to say that you cannot telephone your family member, you cannot telephone your lawyer, provided you are suspected in the case that such communication will lead to tampering of evidence and other suspect will run away. So these are the two scenarios. This right could be denied. But in normal circumstance, such right will be given ordinarily to the suspect. Okay, so this one is very important. Why is it so important? And the third one is admissibility of the suspect statement. Okay, but now, okay, previously, section 112 statement, rakaman percakapan of the accused could be used against him in the trial. Okay, you get what I mean. But now, due to the amendment of section 113, okay, the accused witness statement are protected, are privileged. That means to say, nothing that is unfavorable that the accused said during this section 112 statement could be admitted to against him in the trial. So section 112 statement normally occur after the arrest. Okay, you get what I mean? Okay, after the arrest. But however, there are some exclusion. For example, dying declaration refer to section 32 of this apa nama Evidence Act. Dying declaration, if the police is said to discharge his official duty, the subsection I and also J refer to Siti Aisyah case. So those are the statements that could be admitted, under the section 113. In this particular scenario, for example, you see, if the arrest happens, I scroll up, if the arrest happens on the spot at around 11:45 p.m., so whatever the conversations said to the ASP, Jacob, okay, have you thought of this? Does it amount to section 27 of Evidence Act? Information leading to the discovery of forged credit card. Initially, you see, the police is there for what? Stolen property, isn't it? But subsequently, the characteristic of the investigation has changed. Suddenly, because Chan gave a few direction, where's the room? There's a room, and there was this discovery of forged credit cards, and quite a number of them lah. Okay, 19 credit cards. So if you think about that, would it be section 27 Evidence Act? Would the police during the trial will say that, I discovered this forged credit card. during rakaman percakapan of the accused because I was interrogating him because I said the arrest had happened. So this is something for you to ponder. And I believe this is part of the question as well. Lah. Okay, section 27 of Evidence Act. I hope you know. So this is not privilege, not privilege under section 113 of CPC. Okay. Then subsequently, why the time of arrest is important is that if, let's say, for example, a police detain a suspect for more than 24 hours, then only put this suspect before the magistrate for remand proceeding, by practice, isn't it? By practice, the magistrate will not make further wrong because more than 24 hours, the arrest itself automatically becomes unlawful. The magistrate will never grant a remand. Okay, tangkapan remand, tahanan remand tidak boleh berlaku kerana tangkapan adalah tidak berdasarkan undang-undang. As simple as that. So the accused will be just released like that. Okay. And civil liability and personal remedies is like what I said lah. If you detain more than 24 hours, then the suspect can sue the government of Malaysia for forced imprisonment. Okay, so this is why, based on the reason list down in A, B, C, D, E, the time of arrest is very important. Okay. Then C, you are asked to explain what is the search and what is the seizure. Okay, the search itself, the examiner is quite kind to you. They already put this is a search without warrant. Okay, so search means they are conducting a serbuan to find evidence or items that is highly connected to the crimes. So this is the purpose of a search. Okay, so Section 62 CPC, you have to read together with Section 435 in order to complete your answer. Why is that so? Normally, if the search itself, okay, in the question itself, will be accompanied by the seizure. Okay, bongkar lah. Okay, ada barang-barang bongkar. Okay, so this form a complete chain of evidence. Okay, so these two sections must be read together. Okay, section 62, because you have rights to property, isn't it? So no police official shall just trespass your house and conduct the search according to their wish. Section 62 make it very clear that only the inspector not below the rank of not below the rank of inspector can conduct the search. Okay, and if he has reasonable things to believe that, okay, I think I missed out one thing, the property is stolen or items have been hide there. A few reasons only. You want to check, you want to do search, you must know the rationale behind the law itself. What is the purpose of that search? You buat serbuan buat apa? Okay, the serbuan normally is to discover the stolen item, theft items, or some things that do not disclose to the public. You have hide something lah. So that's why the search is to facilitate the investigation process. Okay. Otherwise, you do a search without warrant, and you must remember this is a search that is done by the police officer itself without the authority from the judiciary, the magistrate did not consent to it. So, unless you have a good reason, meaning to say, such search is so urgent, if it is not being conducted immediately, the items will be moved away from the site. So this is one of the reasoning that search without warrant could be conducted. Okay, and if you look at CPC correctly, section 62 onwards to section 63 provides you a clear procedural rules on how the search should be conducted. Okay, you have to cross-refer to section 65 because you cannot conduct a search in an empty room without any occupant. This is entirely not fair. And this will cause planting of evidence. Take, for example, if I'm not around in my house now, even though the raiding team, the sub one, is conducted by inspector, two sergeants, and a few lance corporal, they raided my house and then they found drugs and also gold inside my house, for example. This search itself will not be valid. And it will cause miscarriage of justice because the occupant is not inside the house. So we can argue in the court that we are not in the control and the custody of this property at this moment. So we are not liable for whatever found inside the house. We will say that the police have planted this to frame me. Okay, so this is one reason. The occupant must be there, section 65. And normally, the occupant will be asked to sign the search list. Okay, so very important also. Whatever discover, the police will ask them to sign. Okay, sometimes this is called senarai, geleda. Sometimes it is called senarai penyitaan. Okay, it use interchangeably inside the court Okay, penyitaan That means to say the suspect acknowledged that the thing had been found inside the property, and normally the police will label each items clearly. For example, they will use exhibit A, exhibit B, exhibit C. For example, exhibit A, 19 credit cards bearing the name of Chan. B, 3 machines. C, 1 iPhone. Something like that. This is search list and then Chan has to sign and acknowledge. So this is the clear procedure, section 64. Okay. So after the search and also the seize, what the police should do is that the police also, because they are considered the RO, raiding officer. So far can understand me? Is it too technical for you all? No, okay. If let's say, for example, the police have finished raiding the place, they need to make a police report at the nearest police station. What they need to report is that, okay, saya ASP Yaakob bersama dengan rakan pekerja, for example, Sarjan Chee, okay, Sarjan Muhammad, one Lance Corporal Ali have conducted the search so and so place, and we have seen one accused, Mr. Chan, and the list of items seized is as follow: 19 credit card, the 3 machines are there, as well as 1 iPhone. So these police report itself will serve as a contemporaneous evidence as in, as in what? As in for the trial later to say that this search has been conducted. There is no way that the police is making up the story and there are items seized. Okay. So seizure, you have to refer to section 435. Okay. Section 435 is about the seizure of items lah. Okay. If you look at section 435 itself, it say stolen item. But it is not just limited to stolen item itself, Whatever items that is related to crimes. Okay, take for example lah. Chan here had been involved in credit card forgery, isn't it? So by right, if you read the title of section 45 or 435, if you look at your CPC, it says power of police to seize property suspected of being stolen. The credit card, he bought it, probably he bought it from China and then printed out lah. Okay, so that one is not considered a stolen item, isn't it? The printer also is not considered a stolen item because he would have bought it elsewhere for his criminal purpose. But somehow or other, this is related or create suspicion to the crime of forgery of credit card. So all these items could be seized under section 435. Okay, section 435. Okay. Okay. So usually what is going to happen to this the seized item will be similar with the search itself. The police will make a police report after the raid had been done. And uh, if let's say, for example, all this item was seized, but Chan was not charged. Dia tak hadap ke mahkamah, was not charged at all. So what happened to the seized item? What happened to the iPhone in particular? Because iPhone is most expensive, isn't it? This is being seized by the police. Okay. Normally, we as a defense counsel, we will wait lah. We will wait for the charge to happen. If it doesn't happen, like for example, 6 months already passed, Chan is still okay. There's no pertuduhan, no summon, whatever, to be issued against him. So we will write into the police to ask for the return of those seized items. Okay, and the police cannot just return to us like that. They will have to file a notice also. Okay, a motion under section 413 CPC. This is usually done by DPP on behalf of police to get instruction from the magistrate about what to do with the seized item. There's only two possibilities. One, the item could be forfeited, dilupuskan hak. That means to say the iPhone is no longer yours lah. It belongs to the Kerajaan Malaysia. Second, the item could be returned back to Chan. Okay, so this is the full process of search and seizure. Okay, not too hard lah. If you don't read just the uh just don't read the statute itself. You try to be a little bit imaginary, try to relate to what is happening in the reality. It will make your life much easier. If you remember the statute just plainly without thorough understanding and appreciation of the reality, I don't think you can do well in this exam, because this exam is very practical. Okay. D, okay, this happens when Chan has been charged with Section 474, read together with Section 467 of Penal Code. Okay, so that is they are testing you on the area of apa nama, the trial and also sentencing jurisdiction of which court. But I think this question, if you want to check the the schedule behind the what we call the, you know where to look for the answer, isn't it? The answer is where, the penal code is not being provided to you, but if you read the column, the schedule behind your CPC, actually you can see, 474, okay? Having possession of a document, knowing it to be forged with intent to use it as genuine. Nowhere to use, where you can find the answer, very important, is at the back of your CPC. There is one schedule and you can read it there. So the sentence is imprisonment, okay? Imprisonment. And also, if you read together with section 467, okay? 467. Okay. Forgery of a valuable security, will, or authority. So this one carries the imprisonment for 20 years and fine. So automatically 20 years will make the trial and sentencing jurisdiction to fall under session court. Okay, session court very important because mahkamah itu apa? Session court can give sentences, all the sentences except death. Okay. So you have to cross-refer to Subordinate Court Act 1948. You have to read section 63 for the trial jurisdiction. Trial jurisdiction means that the court is the right forum to hear that particular offense, to hear untuk mendengar. So this is the trial jurisdiction. So this one is actually fulfilled, and section 64 of the same act provide that session court has the sentencing jurisdiction, because the comment is very simple. They can sentence any punishment except death penalty. Okay, one more thing also very important, because from the facts itself, this incident happens where? In Kampung Baru, Aigero, Melaka, isn't it? So one more thing you must put is, where is the proper place? What is the territorial jurisdiction that the trial should be conducted? Okay, so you have to write section 121 of CPC. If let's say, for example, the crime is committed in Aigero, and all the witnesses are coming from Aigero Balai Police, for example. So for the convenience of the witness to give evidence, etc., no need to carry the credit card machines with a van to a very far place. Normally, it will be done at the local court. You get what I mean? Okay, but somehow or other, there is no Mahkamah Session Aigero. They put it together under one complex. Okay, so the session court at Malacca is the right forum here. Okay, so after discussing trial jurisdiction, sentencing jurisdiction, as well as territorial jurisdiction, you hereby conclude that session court at Malacca is the right place to give uh, to give trial to Chan. Okay, so this question, I think, not too hard, not too hard. Okay, we move to question two. I think question two quite hard, to be frank. Question two quite hard. First, question A is Roman 1 lah. They ask you to write short notes about the transfer of cases from one session court to another session court. Okay, there are several types of transfer that could happen. Okay, one, from the court of same jurisdiction, for example, session court Melaka, SC Melaka to SC Seremban. Okay, this is called lateral transfer because they are of the same power, session court to session court. Okay, another form is called vertical transfer. Vertical transfer, it could go up, for example, from session court to high court, or it could go down from high court to session court or magistrate court. So this is vertical transfer. Transfer is quite hard. Even I admit to you, before I went into practice, I was quite confused about this transfer thing. Okay, particularly when you are reading this transfer of proceeding or transfer of case chapter, you must understand this is what type of transfer first. And then second question that you should ask yourself, who apply for this transfer? Very important, because if the person that apply the transfer is DPP from the prosecution, they can use simply any provision, Section 177, 417, 418A, or they can use, if let's say the accused, then the option is limited, 417 only. Okay, and if it is coming from court, let's say the mahkamah, the judge is the one that transfer, then 417, 177 could be used. Okay, eventually, you must understand why the transfer should happen. Why this court is not good enough to hear that particular case. Okay, it matters. And normally the judge will not simply allow for the transfer applied by the accused. Okay, but DPP can. Okay, eventually, at the end of the day, criminal cases, isn't it? PP or Attorney General under Article 145 of Federal Constitution, they have absolute power. They can decide who to sue. They can decide where to sue. They can decide when to sue. Okay, and they can decide what to sue as well. So it's actually a very big power. Virtually, let's say, for example, I and a group of friends was caught for drug possession. There's a pack of ketamine found in the karaoke while I was drinking with my friends. They can release 3 person and charge only Chee Hui Bing. Their absolute power. You cannot question them. They can bring me to KL and charge me in KL. Also can, because they said the raiding team is from Bukit Aman. This is also their power. Okay, and they can decide to sue me now or sue me 5 years later. You cannot say there is a lapse of time, limitation period set in. So this is, um, I mean, PP lah. DPP has a very great power in deciding the fate of the criminals in Malaysia. So this is the general rule. Okay. Even in most of the case, DNAA, in Malaysia, we are quite famous for DNAA, isn't it? Discharged, but not amounting to acquittal. Okay, DNA means the charge digugurkan. We drop the charge against you. And this one is not decided by the judge. This is decided by the DPP. DPP is the one that will stand up. Case ni pihak pendakwaan memohon satu perintah dibebaskan tanpa dilepaskan. Dibebaskan tanpa dilepaskan. DNAA. So the judge will just listen and give such order. Okay. So back to the question. Lateral transfer. Lateral transfer, you have to refer Section 104 Subordinate Court Act, whereby a session court judge in the interest of justice. This is a very broad term. Nobody knows what does it mean by the interest of justice. Okay. To remit any criminal cause of matter to any other session court or magistrate court that possess the jurisdiction over the offense. Okay. And you have to read together with Section 99A. Section 99A is quite special. It gives rise to several provisions. It is not a schedule. It is just a list of provision. So paragraph 3, subrule 2 of third schedule said that the session court or the subordinate court actually will have inherent power to do horizontal transfer on its own motion or open application. Okay, that means to say the judge himself is free to go. Okay, but I say to you, who has the biggest power to initiate, conduct, and also to commence the trial is at the hand of PP. Remember, always remember, PP is the key person. In our adversarial system, the judge play a passive role. Okay. So section 177 177 also provide that the judge has power to do the transfer, but subjected if it is going to high court if it's going to high court, okay, PP's written consent, keizinan, they will write you izin untuk mendakwa. Okay, this is the consent must be obtained from DPP, the AG chambers. You must get the consent. Okay. Okay, so this is how. So, and other than that, even though section 104, 177, you must write something here. PP has constitutional discretion. Let's say, for example, if the session court judge want to transfer, but DPP insists that because of the convenience of the evidence, because of the convenience of the witness, the trial should actually be conducted in Malacca. So tak jadi, tak jadi transfer, you must remember, DPP is the one that decide where to charge also. So you can use up Article 145, Subrule 3, Section 376 CPC. It is like a check. Okay. So the judge cannot push here and there the case. Okay. Let's say, for example, let's say if let's say lah, for example, the transfer is refused, the lateral transfer could still happen open application of the party under section 417 CPC. Okay, 417 accused can apply. Remember, accused very narrow. The only applications that accused can go is section 417. And I tell you, in reality, it's super hard to get. Very difficult. Very difficult. Okay. So the trial, you can regurgitate lah, section 417 out, in which the High Court judge can decide based on a few factors, for example, fair and impartial trial, the legal complexity involved, the crime scene location, and like what I have told you, the party's convenience. The party's convenience here is not the forum of non-convenience as in the civil case. In the civil case, the territorial jurisdiction is in favor of the defendant, isn't it? Because the plaintiff brought the case whereby it caused hardship for the defendants to travel, but whereby in criminal case, they don't care whether the accused is actually having a residential address in Johor Bahru, but the crime scene actually is in Malacca. The Malacca court will be the ultimate forum. Okay, you get me, eh? So after that, you discuss a bit session to session transfer, three pillars, textual authority of this. Okay, this few section you must cite. If not, if you are just talking from the air itself, you won't get marked. You must be very particular with the section cited. Okay, and you must realize that the judge does not have absolute power. The one that will have bigger power in terms of deciding the forum is still at the hand of prosecution. Okay, prosecution. So this is what I'm trying to tell you. Okay. Question subrule B, subrule 2, sorry. Transfer of case by the prosecution before trial. Okay. Prosecution's applications is much easier. Okay. In practice, normally what they do, they rely on section 418A. They will just need to produce a certificate from PP, okay, saying that this case transfer to High Court, Kuala Lumpur. That's it. They do not need to give any reason. That's why I said, who, what, where, when, and even how lah. Almost 5W1H of the trial itself is at the hand of PP. That's why PP's role sometimes is very controversial here and politically connected as well. Okay, but they do have vast power to do the transfer. First, they can transfer by section 177. They have to apply by notice uso and give reasoning, and normally the judge will give. So this is one way. Section 177A is going to High Court, vertical, going up to High Court from subordinate court. Okay, but provided the charge has been read to the accused, but no evidence has been taken. That means to say, SP1, saksi prosecution yang pertama lah, saksi pendakwaan yang pertama belum lagi dipanggil. Apa-apa keterangan pun tak ada diberikan lagi. Then section 177A, DPP can apply to get the accused transferred to the High Court. Okay. or by certain section also can, section 41A of DDA, okay, provided there is written consent by PP. So second is like what I say, section 418A CPC. So long you tender the certificate by PP, then you can transfer the case up. Normally, this is done in those high profile case. Okay. And third, PP may apply to seek a high court transfer under section 417 on its own motion, okay, and give reasoning. Okay. Normally, the DPP will not go by section 417. They prefer 418A. Very easy. Just tender the certificate, no need further argument. Okay. And the defense counsel cannot challenge them also. Okay. So this is constitutional prerogative. Okay. And B, they ask you to discuss one statement. And where is the statement coming from? Is from one case here. PP against Ho Hua Tiong. If you really have no idea uh, about this case at all, I advise you not to glantong. If you glantong, normally you will not end up so well in your discussion. As a discussion, the facts of this case is like this. The case, okay, you see, the case actually happens whereby a session court judge feels that an offense should go down to magistrate court. So on his own motion, he transferred the case downward to magistrate. That means to say the session court judge transfer a case down to magistrate. Okay, so whether it is okay or not, if it is done without the consent of public prosecutor. Okay, so again, I say that PP has the decisive power to decide where is the initial forum. Okay, they have the absolute choice forum. So you rely on Article 145, Subrule 3 of Federal Constitution, as well as Section 376 of CPC. Okay, so PP has the power to institute and conduct prosecution. Okay, institute means to start lah. Okay, to start, to begin. To conduct means how you behave during the trial. Okay, so the what we call this discretion itself is not procedural, it is substantive. So section 104 SCA, despite superficially allow a session court judge to transfer the matter in the interest of justice, but based on the case of PP against Ho Hua Tiong, the provision cannot be exercised in a way to frustrate PP constitutional mandate. That is to say, for example, if the court on its own motion transfer the case downward, but DPP is not agreeable, it could not be done. Okay, please remember what I said. If let's say you are not getting the approval or the acknowledgement from the DPP is not agreeable to the transfer, then this what we call this transfer itself is not legal. Okay, it's not legal. It should not have happened in the first place. So this is what this case is all about. Okay, but like what I said, this question itself is quite hard. I would say it's quite hard. Okay, question C invites you to discuss one recent case. Actually, not recent. It happens last 2 years, whereby the late Datuk Sri Gopal Sri Ram, okay, Sri Ram was appointed by PP as Deputy Public Prosecutor, okay, to sit for the case in Rosma Manso. Okay. In fact, Najib as well. Lah. Okay. Before that, when Datuk Sri Anwar Ibrahim was in his other cases, Tan Sri Shafi'i was also, as a private lawyer, as a private advocate and solicitor, they also assumed the role of DPP, being appointed as an external DPP to charge Datuk Sri Anwar Ibrahim in the court. Okay, so this question invites you, this thing already happened, okay, and the appointment itself is not only announced by the PP in a media release, but a copy of letter of appointment of that particular lawyer as senior deputy public prosecutor was shown to the accused counsel at the request of the accused counsel. So accused applied to disqualify the private advocate and solicitor from continuing to act as a prosecutor. So as a high court judge, how will you decide on the merits of the case? If you read the case of Rosman Manso against PP, okay, you can make out the answer lah. Okay, I will actually, if let's say I act for you have to assume the role of a high court judge in this case lah. Okay. So when you read the extensive submission, the affidavit, and also the notice also, you will say that I will dismiss both prayers. What is the reason? Okay. Again, I think most of this question is testing you whether you know the power of PP or not. It is still back to Article 145 and also Section 376 of Criminal Code, Criminal Procedural Code. Okay, so PP has power to appoint any advocate. If you read thoroughly, Section 376. Okay, 376. Okay, you pause for a while and you read it. Okay. So they can appoint anyone, they can appoint anyone to be vested or to exercise the power of DPP. Okay, and this is a power which is exclusive and not reviewable. Okay, regardless whether this is done in bad faith, illegal, irrationality, you cannot challenge lah. So this is the grounds for normally we do judicial review lah. We have all these kind of grounds. So actually cannot and judicial treatments of letter of appointment. Okay. So in Rosma Manso, this letter of appointment, isn't it? Unless it causes grave danger to the justice. That is to say, there's a miscarriage of justice. Simply giving a letter of appointment like this could not prejudice the accused. You get what I mean? It's just merely telling you that AG Chambers had give something like employment letter to Gopal Sriram so that he could act as a SDPP in this matter to conduct the trial, to institute the trial on behalf of AG Chambers. Okay, so without any exceptional circumstances, you cannot, unless you have conflict of interest lah. That means to say the said SDPP has connection with the accused, last time act for the accused before, having some financial interest, or been consulted with by that particular accused before. Otherwise, you cannot dismiss. Okay, so this is again the LOA. Okay, and the comment on press release. Don't forget, this becomes a hoo-ha issue, isn't it? So the accused will submit 2 points. First, whether the LOA is actually legit or not. Okay, given by AG Chambers to Gopal Sriram, is whether it is lawful or not. Second thing, can you publish in media? Would it amount to sub judice comment or not? Contempt of court lah. Because the trial is ongoing, suddenly you make a hoo-ha. What is the purpose here? Okay, you want to put down the accused or what? This is roughly the submission that is going to made out by the defense counsel. But if you read the question properly, there's nothing to do with sub judice comment as well, because the statement itself is just telling the public that, okay, there is a private lawyer being appointed to be SDPP who will take over the case from AG Chambers and conduct the trial. That's it. So no sub judice rule. You didn't say that the court should rule in favor of the accused or what? You did not say that. You did not use the media or the public voice to to exert pressure on the court. So this is not sub judice comment. Okay. And public interest consideration. Somehow or rather, you must also think that in a broad looking, why accused wanted to raise objection at this moment? Would it be a mere delay tactic? Normally, if you have this sort of challenges to go up, High Court, Court of Appeal, then Federal Court, etc., the trial cannot be go on. You can file a notice pergantungan proceeding, stay. That means the whole case cannot be proceed to trial. You get what I mean? Until this matter has been disposed by the higher court. So that means to say you enjoy a certain period of time. So the accused did not need to go to the trial. Okay? Probably will drag another 3 to 5 years to finish the matter like that. Okay. So for the foregoing reason, I will actually dismiss the accused counsel application. Okay, so this is the reasoning here. Okay. At this moment, do you have any question? Am I confusing you, or you can understand what I'm trying to say?
Mr. Chi, I have a question
Yes.
regarding the transfer of cases. So when the court transfer the cases from Sessions Court to the High Court,
Yes.
does the appeal up to Federal Court means that you have to start the case at High Court, right? So if you transfer the case from Sessions Court to the High Court, then does that mean the case started at High Court or Sessions Court?
No, the court of first instance is the one that matter most. Okay. This is just some sort like an interlocutory application. This is not full trial yet. For example, in between the trial, we have noted something. For example, we want to raise preliminary objection towards the appointment of SDPP is not legal. We can file a notice of motion, notice also, supported by affidavit signed by the accused saying that, okay, you see the appointment of Gopal Sriram is not according to the law. He has conflict of interest here. Previously, he was a judge. Now he became a DPP. Now he's a retiring punya advocate and solicitor. And there are so many people in your AG chambers. Why Why on earth you cannot find a suitable candidate to conduct the trial? So this case itself, the notice also will still be heard in the court that first instance, That means to say that the court that the case originally come from. Take for example, Rosmah Mansor case, the court of first instance is KL High Court, isn't it? Then High Court judge will say, okay, I dismiss the application. I say that the accused is a delay tactic. So there are two tiers of appeal. For this interlocutory application, I'll make it easier. For this application itself, the accused will have two chances, to appeal to Court of Appeal and lose again, they can appeal to Federal Court for this particular application. You get me? But still, the court of first instance that trial this case, isn't it? It's not Court of Appeal and Federal Court. It should be High Court KL. This is where the case started, originally coming from. Okay? You get what I'm saying? Uh, okay.
Yeah, no, my question is that if the case started at Sessions Court,
Hmm.
so you bring the case to the Sessions Court and then the Sessions Court transmit the
Transfer
case
to
to High
or
Court.
transfer to High Court. So where's
Yeah.
the court of first instance, isn't it? The transfer can only take place before any evidence the trial is being conducted. You get me?
Mhm.
When the charge
Mhm.
has been read to the accused, before SP1, saksi pendakwaan 1 dipanggil, then the transfer. Then the whole trial itself is deemed to happen in the place where the transfer took place. For example, session court to high court. High court lah. So your ultimate forum to appeal will be CAFC. Two tiers lah. Like that. Okay. Okay, question 3A, you are asked to explain consent and sanction to institute or commence proceeding and the effect of lack of each of them. Okay, like I say, PPs has good power, very great power in deciding the fates of the accused. Okay, but sometimes some mistake could happen. You see, in Malaysia, it's like that. Okay, there are several enforcer. Okay. Not necessarily the police, immigration officer, custom that we commonly know. For example, the case that I often deal with, Ministry of Health. Inside, we have bahagian pharmacy. Okay, pharmacy, and they have medical device authorities, pihak berkuasa peranti perubatan. Okay. Inside all these unit, they have their so-called legal of unit, legal unit. And each legal unit, they will be supplied with their own prosecuting officer, PO. Okay. Normally, the consent and sanction issue will happen in the event that that particular legal unit punya prosecuting officer they fail to obtain apa nama keizinan ataupun kebenaran daripada PP untuk memulakan satu dakwaan di mahkamah. Okay, very important because at the end of the day you must understand AG chambers AG chambers or PP lah, okay, has been given constitutional rights, 145, to decide who, like I said, the 5W1H, I shouldn't be repeating them too many times, in the criminal court. So no other enforcement body can bypass this. Okay, so the reasoning why they should have a consent and sanction is that before a suspect could be charged in court, DPP has to filter and also read the investigation paper to see the chain of evidence is okay or not. If it's not okay, they won't give you the keizinan untuk mendakwa. As simple as that. It's like a counter check mechanism so that the enforcement body will not simply bypass the power of AG chambers and straight away court and accuse to the court. Okay, because you must know the stigma to go to criminal court is not a good thing. Before you are actually found guilty, the society will look down on you already. So this is part of the reason why they need a sanction and consent. Okay, the consent is the permission to institute a prosecution. Okay, if institution occurs when the accused has been read with the charge and been called to plead. Okay, bacakan pertuduhan, lepas tu orang kena tuduh akan dipanggil mengaku bersalah atau tidak. So this is the first step lah. This is called institution of the the proceeding. And the consent must exist before this lah. Normally, before the charge is being read, the prosecuting officer, the PO, other than the one that coming from this AG chambers, AG chambers they won't give you any this sort of consent because DPP is what? DPP is outer ego. Okay, outer ego of PP. That means to say they can represent PP in all other vested power except for the personal power of PP. That means they can represent PP lah, as a whole, nearly as a whole. Okay. So the prosecuting officer must get the consent first. Okay. The statute that demand consent include section 158 MACC, section 177A CPC. Okay, that means to say the case triable in High Court, for example, murder case, FIPA case, the firearm case, okay, SOSMA case that carry death penalty. So you need section 177A approval by PP. Okay, and the consent could be oral and imply lah. Because like I say, if the prosecuting officer is DPP, no written consent is required. Okay, because his outer ego. If the consent itself is not there, then if PO, the prosecuting officer, for example, the legal officer coming from Ministry of Health is conducting the trial, at the end, the defense counsel can submit that this trial itself is irregular. Tidak teratur lah, because you tak ada keizinan pun untuk mendakwa OKT saya. So this one is jurisdictional, It's not just a technical error. It is not curable. And it will render the whole trial to be illegal and nullity. At the end of the day, this the accused could be DNAA because of this problem. Okay. And sanction to prosecute. Sanction means something like acknowledgement, cognizance. Ambil tahu lah. Okay. So this is also happens before the process. And particular section that you should refer is section 129 of CPC. Okay. You must think behind the scene. Why Section 129 CPC is there? If you look at the offenses, you see, by public servant, perjury, meaning lying in the court, lah, okay, or forgery related offense, they will put section 129 CPC. Okay, for this particular thing, offenses by public servant, we have several cases, coming to our place. For example, a public servant involved in a domestic violence against the wife, even before he got convicted, his job could be suspended, and he will not get salary. Okay, that's why some of the charges against a public servant will require sanction on part of PP. Okay, very important. Okay, and that sanction is only limited to 1 month only. So different with consent, sanction itself must be in written. Okay, written. And normally sanction is not so serious. The lack of sanction itself is not so serious. It is curable under section 422 CPC. 422 CPC is a little bit like your order 1A or order 2, rule 1 of rules of court. This is to salvage technical mistake because nobody can do things perfectly, isn't it? So sometimes technical errors happen. So section 422 is to salvage this sort of technical issue. So lack of sanction is actually not fatal to the case. You can do it later. You can ask for that written sanction later on. Okay. So other discussion which I highlighted is for reading only lah. I don't think you should include it in the what we call in the examination for this particular question because you will run out of time. Okay. So remember, in practice, for practical reason, we will go through the documents. You as a defense counsel, you need to go through, especially it is done by prosecuting officer from other than AG chambers punya orang lah. Okay, like MOH, okay, Kementerian Perdagangan Dalam Negeri, Kos Sara Hidup, those people. Okay, if they send down officer, make sure you check. If it is not there, you can raise preliminary objection. Okay. And question B. Question B asks you, again, relate back to the issue of sanction. This is what I say lah. EPF Act provided that KWSP officer, there is also a legal department, they can conduct the case, provided they need to get sanction from the what we call officer, sorry, the AG chambers. Okay, but according to this statement, whether it is right or not, so this statement itself is entirely coming from one case, Ang Tiam Chum against PP. If you do not know this case, you don't simply write lah. You don't simply write lah because I think the whole flow will be wrong, Okay. Again, you have to relate what is the offense first. Okay, you roughly say this is a offense here and there, but of course this is as a matter of hindsight lah. I have the opportunity to read what is EPF Act all about, and I find the section. That's why I know. But during examination, how you will know what kind of offense is it? Isn't it very difficult? Okay, so section 377B actually permits PP to authorize in writing any person to conduct the prosecution of a seizable offense. So by virtue of section 376 sub rule 4 CPC, DPP enjoys coextensive power with PP. Why I need to use DPP? Okay, because the argument is that the letter of authorization was not personally issued by PP. In PP, there's no argument, isn't it? But this one is actually done by DPP. So the question related here is, does DPP also have the same power as PP in this particular manner? The answer, of course, is yes lah. They enjoy co-extensive power with PP, except for the one personal power, okay, of PP. So therefore, DPP is authorized to sign on PP's behalf. Okay. And some more, you have to apply the principle of generalia specialibus non derogant. You have to look into the act itself to check whether there's a mandatory provision that say that a sanction is a must, shall be acquired from the PP before the proceeding should be conducted. But somehow or other, EPF Act itself is silent about this issue. Okay. So authority of EPF officer in this particular case, he already get letter of authorization signed by DPP. Okay, so section 377 sub-rule B is actually satisfied. And this was actually issued before the trial commenced. That means to say before the plea has been taken from the accused. So based on Ang Tiam Chun, this one is actually legal lah. Okay. So again, you have to talk about the third issue, sorry, whether a sanction is really required in this manner. Okay. But sanction, according to section 129, it is only demanded for classes of offenses. So normally, if you get written authorization letter, isn't it? You do not need to get so-called sanction again, you know. Okay, so no need, and again, you use this uh, the effect of defective sanction, because the whole point asks you to discuss about sanction, isn't it? So, like we have previously discussed, absence of sanction is not fatal. Absence of consent is fatal to the case. So, at the end of the day, you conclude that now the prosecuting EPF officer has written authorization signed by the PP, who act as PP's alter ego. Therefore, such authority is legal. And furthermore, we refer to the specific act, the EPF Act itself. Also, there is no impose of this mandatory requirement of a written sanction. So the prosecution here was properly constituted, and the objection for this ground must be dismissed lah, must fail lah. So this is basically how the thing should go. Okay. Uh, this actually the whole question here wants you to apply the power of PP in a very different manner. But unfortunately, kan, as a student, you will only know a little bit the tip of iceberg of the power of PP. Like for example, they can institute, conduct the proceeding. That's it. But when you look at the reality, this is what I said will happen. The officer from different ministry will conduct the case, but the case uh, will have problems. Like the famous case lah, Repco Holdings, okay, conduct by Security Commission. Okay, last question. Last question, I think is also quite challenging. Okay, here there's one summon case. Uh, okay, summon case, is lighter offense. Okay, lighter offense. Normally, this sort of offense is how to say is normally could be settled with fine with fine. If repeated offense, probably the court will impose a short imprisonment period. Okay, so this is what it meant by saman. So in this case, one orang kena saman, we call OKS, was facing charges under the Communications and Multimedia Act lah. Okay, the MCMC would have charged them lah. Okay, and the punishment has been listed down: a fine not exceeding 50,000 or imprisonment for a term not exceeding 1 year or both. Okay, so OKS after being read with the charge, claimed trial. Okay, that means to say he did not plead guilty, so he asked for trial lah, and subsequently he was released on a bail basis. Okay, now question A asks you to discuss what is the pre-trial process. Remember, pre-trial process, they did not ask you to discuss trials, summary trial. Okay, very different. So pre-trial process means now it's like that. The whole situation is like that. Pertuduhan, the charges has been read to the accused, the OKS lah, orang kena saman, and the OKS here plead not guilty. Okay, mengaku tidak bersalah. Then subsequently, bail isn't it? Okay, ikat jamin. Ikat jamin, after that, he can balik rumah, he can go home, He can go home. So pre-trial means there's a few case management session happens before the tarik perbicaraan. Okay? So all this case management will be called as pre-trial process. That means to say what can happen before the accused dibicarakan, before the prosecution can call their witness to testify. What could be done? Okay, so you can refer to section 17, yeah, section 172A to 172G. Okay, it depends. There are two scenarios here. It is a bit different, Okay, if the accused is represented by lawyer, lawyer. And if the accused is not represented by lawyer from the very beginning, okay, it's different, Okay. So if, let's say, for example, the accused is represented by lawyer, this pre-trial conference, section 172A, will happen. Okay, it will happen. DPP and the lawyer must sit down for a pre-trial conference. This pre-trial conference is free and easy. You can do it at your law firm office. You can also do it at the DPP office. You can even do it in the Starbucks if you are having good relationship with DPP. Okay, you can buy him a latte at the same time discuss the case. It is allowed, Okay, so whereby some information will be exchanged. Normally, the DPP will give you whatever section 51A documents, the photos, the witness statement, the jabatan kimia laporan, or whatsoever the things that they are going to use to charge against your client there. Okay, and both parties list down the issues, and at the same time, so of course we negotiate lah. We negotiate what you can go down to the further charge, lower charge or not, something like that. Okay, this happens only if the orang kena saman has lawyer. If there is no lawyer, there is no pre-trial conference. As simple as that. So section 172B is case management. Okay, this apply whether the accused has representation or not, it doesn't matter. Whereby just now only happened between DPP and lawyer, isn't it? DP and lawyer for pre-trial. But now case management involve new party, the judge or the magistrate. So the location for this sort of case management usually is in the court, whether it is open court or in the chambers, in the chambers of the judge. Okay, normally the case management, the judge will check with DPP whether the documents are ready. Okay, because sometimes when the IO of the case tender the investigation papers, the investigation papers are not perfect yet. Remember, the prosecution bears legal burden to prove the case beyond reasonable doubt, isn't it? So DPP will discuss with IO to furnish whatever the other evidences that is relevant to the case to complete a chain of evidence. So they will take time in such case to prepare the documents before it can surrender or give it to the accused lawyer. So normally this is what is it about lah, section 51A punya documents. Is it ready or not? Okay. So if it is ready, this sort of case management habis. And the judge will fix a date for trial. Bila tarik perbicaraan. Okay. And in between, before the trial happened, the accused lawyer, the OKS lawyer in this particular case, can actually write to DPP, in form 28A. There's a format here. Okay, you use the entitlement. Okay, in the session court at Malacca, for example. Okay, what suit number? Okay, then you ask for a plea bargaining. Okay, mohon rujuk pertuduhan yang dilampir. Okay, dilampir, and then you ask for a plea bargaining. If let's say this one is 50,000 fine maximum, isn't it? In your Form 28A, which you are going to file inside the EFS system, and also give a copy to DPP, you can ask for 5,000. Okay, 5,000. This is plea bargaining. Okay, this is a formal way lah, and DPP will actually having a meeting with their superiors and decide whether they can take this plea bargaining or not. If let's say, for example, the plea bargaining is accepted by DPP, then the whole case will be called to the chambers of the judge, and the judge will also be asked whether they accept or not about the guilty plea. Okay. Sometimes the judge will refuse because the punishment accepted is too low. It's too low. Okay. They have right to turn it down. Okay. If let's say everything is agreed, the judge also agree. DPP will sign. The accused will sign. Okay, so this is section 172D. Uh, that means to say the whole case just ends as a very well agreed term. Okay, you may want to ask, what is the difference between plead guilty on the spot and also plead guilty at this stage? I can tell you, if you get representation from the very beginning, to plead guilty from the beginning, is not a good idea. Because, because why I say so, you lose the chance to bargain for a better deal. You get me? If let's say, for example, you are charged with section 14 of SOCA, okay? Jenayah seksual terhadap kanak-kanak, the maximum punishment is 20 years imprisonment and also the rotan isn't it? Rotan. If let's say, for example, you plead guilty to the charge straight away after understanding nature and consequences of that particular plea, the judge is still able to punish you up to 20 years, imprisonment, because they can pass any sentence that is according to the law. You cannot say she's wrong, isn't it? So you are having problems. This guilty plea here under section 172C enables you to do, OKS to do a plea under everyone mutual understanding. So the outcome is more predictable. That's all. More predictable. Okay. And in fact, as a practicing lawyer, isn't it? Official guilty plea will rarely happen. It will happen informally. Informally. That means to say we just talk to the DPP. If the DPP allow kita masuk itu chamber sama-sama, bincang dengan magistrate. Magistrate also allow, or then we will advise our client to plead guilty. As simple as that. Okay? In reality lah, but in examination you cannot you cannot write like that lah, isn't it? So after the guilty plea, the effect is same with the after the plea bargain, the effect is similar to guilty plea. You cannot appeal to the conviction. You cannot appeal to the conviction, but you can appeal towards the quantum of sentences. Okay, this is quite similar lah. So other than that, let guilty plea and protection for guilty plea, all that is without prejudice basis lah. We call without prejudice means this is not a proper word, but somehow or other the judge should not be biased if we enter into this sort of plea bargaining process. Okay, she should still remain neutral. Okay, so what is the purpose of this pre-trial process? In Malaysia, frankly speaking, if you are being charged with one simple offense, the length of the waiting time is about 1 to 2 years. So our court has a lot of backlogs of case. So pre-trial process actually provide a fast track for all the parties. So we don't have to waste time. And OKS can get whatever lighter punishment since he did it. Okay. There's a fair play, safe cost, and balanced justice. Okay. So these are the purpose of a pre-trial process as a whole. Just like the civil case, we have PTCM. Okay. It's the same thing. It's the same thing. Okay. And question B, you are asked to explain the type of bail referred in the facts. Okay. So the type of bill here is the priority is that you must write this is a bill pending trial. Okay, bail also very interesting but difficult. who can give bail? Do you have idea who can give bail in Malaysia? Yeah, very good. Police and court, huh? Okay. Police one is the police bail. Okay. And the court one is actually the court bail. So in this case, this is a court bail. Okay. Police and court, they have rights to give bail. But the police one is usually bailable offense. Okay. Bailable offense only. The court can give bail to bailable, unbailable, and sometimes in a very exceptional circumstances, uh, those non-bailable also, the one by right cannot be bailed at all. Sometimes they can allow, like the case of the Bawan Singh in there. Okay, exceptional condition. Okay, so this is the different type. And second thing is you have to look at the stage of the proceeding. Proceeding. Is it pending for trial temporarily? I mean, after the charge has been read, the OKS temporarily released to go home before the trial date. So this is bail pending trial. Okay, take for example, there is one. If the conviction is upheld by the judge, now the case is proceed to appeal to High Court lah, appeal. Meanwhile, there's a waiting period, isn't it? The only outcome is that the accused or the convicted stay in the lockup or the prison until the appeal date, or he can also apply for bail pending appeal. Okay, you get me? So there are two types of stages of proceeding where the bill can be granted. Okay, so when we look at this, section 233 of CMA 1998, this is not more than 1 year imprisonment. So this is definitely a bailable offense. Okay, so bailable offense you go straight away to discuss section 387. Okay, where the session court judge have two alternatives. They can release the OKS on a bail bond with sureties, penjamin lah, berapa orang penjamin, or they can release without surety. That means to say on his own, he walk away lah, just like that, without penjamin. Okay, so this is the power. So actually, the judge here opt for personal bond without any surety, isn't it? So this is, as a whole, you say that this is court bail pending trial by way of personal bond. Okay, under section 387 sub rule 2. Okay, so this is the accurate answer. And question C, you are asked to comment whether the session court judge did the right thing or not. So how do you want to justify the decision made by the session court judge? Okay, first you say that the charge itself is the offense. Okay, the offense itself is a bailable one as of right. So the court actually refer to section 387, okay, whereby sub-rule 1 give them the power. The court can actually, not can, shall release the accused of a non-bailable offense on a bail basis. That means to say, as of right, the court must give bail. The court has no alternative to what we call to further lock up the accused. Okay. Hmm. And so this is in reference to Dato Mat Shah against PP. And the judge order is actually firmly rooted in the mandatory language of section 387 sub rule 2, and there is no other special reason that the court can say no to this particular what we call particular requirement, or the request of DPP to give 10,000 ringgit and one surety. Okay, so section 387 said that the court may not necessarily consider, because it is available of as of right. So imposing this sort of bond sum and also penjamin sometimes can cause hardship on the OKS, because at the end of the day, you must remember, summon case is a lighter version of the offense. It is not a, a, what we call a seizable offense lah. This is not a seizable offense. Seizable offense in Malaysia, normally the court will give um, the bond sum, how much you should pay. For example, 5,000 to 10,000 per charge, as well as the attendance must be secure by one surety. If let's say, for example, the accused abscond, the surety will need to come to court, to explain why the accused is not coming to the court on this particular date, like that. Okay. So in order to get the reasonable amount of that particular bond and also this surety, the prosecution will need to advance the evidence. There is a possibility that the accused will get abscond, or if let's say the accused is on bail, he has the risk to cause damage to this case, to go and kacau the witness, or in the case of domestic violence or incestuous rape, that means the probably the stepfather raping the daughter. If there is a chance that both the victim and also the accused get near together, then the bail will be put at a very high ceiling price, or it may not be even granted also. So these are the consideration that the prosecution must put forward to the court. Okay, but here on the defense side, the OKS already said that he's of good character and there is no flight risk. Therefore, this is a very good supporting, what we call supporting statement to grant an easy bail. And some more, you must always highlight that the bill itself is not meant to be punitive in nature. It meant to only with one purpose, to secure the attendance of the accused to the court when the date is fixed. Okay, so this one, the bill cannot be too excessive lah. Like the one uh, Rosmah Mansor case, they impose 1 million ringgit on Datin Sri Rosmah Mansor, in relationship to the bill lah, the bond sum. So Tan Sri Shafi argue that this is exorbitant and excessive, but still the court gave. Okay, but by right, the bill itself should not be punitive in nature, but it has to be taken account of the factual scenario of the case, as compared to the thing seized, so many diamonds and all that. Okay, so 1 million is virtually nothing, isn't it? You get what I mean? Okay, but having said so, it should not be punitive in nature. So at the end of the day, you have to conclude that the SCJ decision is legally sound and defensible because the offense is valuable as of right. Number one, sure, you must give already. So that one, no dispute. So section 387 sub rule 2 said that you can do it without surety, without bond at all. Okay. And third is that the session court judge will have considered the good character and also flight risk factors here, lah, isn't it? And found that the money is not necessary to be attached as one of the condition for the bail. Okay. So the prosecution's interest, if let's say, for example, in this case, prosecution is not happy, they can actually appeal. They can actually appeal to High Court to seek for revocation or variation, okay, of this bail itself. Okay. So far, is there any question